So let's start with Massimiliano. I always, if I should read you the CV, the short CV of Massimiliano, it will take me half an hour. His CV is always very rich, but the advantage is that you all know him and that you all know his multitasking capabilities. So Massimiliano is everything that a maritime lawyer can become, an excellent practitioner in the Studio Legale Zunarelli, and also an excellent academic who started his career in Bologna. And this is the big news. After a couple of years at the University of Teramo, now he returned to Bologna, starting today, I think, or something like this, from the message, starting this week, actually.
Yes.
So Massimiliano is now got a permanent position at his alma mater Studiorum in Bologna, where he started his studies. He is, of course, known to all of you as editor of Diritto Marittimo, co-editor of Diritto Marittimo Quaderni, member of the editorial boards of many magazines, author of many monographs, articles, and as I could say, I could speak a lot about Massimiliano. But without further ado, I would give him the floor, and the topics is what we all follow very closely during the recent times, the aspects of autonomous shipping. So Massimiliano, please, the floor is yours.
Thank you very much, Mr. Chairman. Thanks again for the invitation, and I truly do apologize not being there, but as you mentioned, I started my new adventure here in my hometown at the university this week substantially, so it wasn't possible to leave Emilia-Romagna this time. Anyway, I hope that for the sightseeing tour of this afternoon, there will be a GoPro too, so that I can enjoy it as well, even if I'm far. So I will today I will try to focus on a topic that is being studied, especially in the last years, in many different countries and by different academics, and there are already some theories. And let's say that the lecture of today is related to the research, my research that is ongoing on this topic, and is related to the mass phenomenon, so maritime autonomous surface ships, and the channeling of the liability. So I will try to give a very brief landscape of the possible regulatory approaches at international, uniform and national levels concerning the channeling of the liability in case of autonomous ships. First of all, I have to point out that clearly maritime law is perhaps one of the most stable of all branches of law, having maintained, as it is refractory to time passing, almost unchanged over the centuries, many of the institutes and figures that most characterize it. For example, general average, salvage, limitation of liability of the ship owner, the charter party, the bill of lading, the role of the master and the crew. This notwithstanding a reality that is pervaded with a greater acceleration in recent decades by incessant changes in all areas of economic, science, politics, and society in general. So now the continuous advances of technologies are revolutionizing the world of sea transport. And for this reason, the legislators, the lawmakers are called upon to resort to a balance between flexibility and rigidity. So this is even more essential in relation to the phenomenon of the UVs, so the unmanned vehicles in general, which are acquiring clearly an increasingly important role in the various modes of transport, and includes not only the unmanned aerial vehicles, not only the unmanned ground vehicles, but precisely unmanned maritime or marine vehicles. So, especially focusing on the latter category, they can be distinguished taking into account the environment in which they operate, for example, above or below the water surface, and then again can be distinguished in unmanned water surface vehicles and unmanned underwater vehicles. And they can be distinguished also on the basis of their degree of autonomy with respect to human intervention. So the growing success of unmanned vehicles, especially unmanned maritime vehicles in their various forms, is largely due to a variety of uses to which, for some time now, they have been destined. We can consider the civilian uses, the purposes of seabed mapping, the mine and prospecting, the positioning of submarine cables, the maintenance of oil platforms and pipelines, the search for wrecks, scientific researches, but also we can think to military uses, the espionage, the mining, surveillance, assaults, and so on. However, their use in the commercial transport of goods and passengers is still in its infancy, even if some prototypes intended for it have already been built and tested, and others are under construction. I can mention, for example, Yara Birkeland, which is unmanned ships that has substantially been finalized this year, I think, by a group of companies, also managed by Fincantieri, and is a typical example of this kind of new prototypes that are already working. So, considering the role in transport among the various UMVs, it is precisely the unmanned ships that arose, in my point of view, the greatest interest, if only for the massive use that could be made of them within a few years, and for the consequent impacts that this would have on the whole sector of transport by sea. So, the evolution in science and technologies that we are witnessing is modifying deeply the perception acquired up to now of the notion of vessel, being deprived of a feature that, notwithstanding all the changes undergone in the last centuries, has always been preserved, which is the presence of the human element. So first of all, we have to reason on the possibility of reconsidering the concept of ship, especially in order to avoid a dangerous substantial regulatory vacuum, because if a specific structure is a ship or a vessel, in that case, there is a legal background that can be applied. If a specific structure is not possible to be considered a vessel, in that case, a regulatory vacuum could be present. So the particular relevance of the problem and its transnational connotation have prompted European institutions and international organizations to activate ad hoc projects and research groups. On the one hand, we have the European Commission that has promoted and co-financed the Moonin project, which is more or less, I think, Maritime Unmanned Navigation and Intelligence in Network. Moonin project, whose official kickoff meeting has been in 2012, so there are some years that is ongoing. On the other hand, at the international level, the IMO, the International Maritime Organization, has included in its 6-year strategy, from 2018 to 2023, as a second strategic direction that of integrate new and advancing technologies in the regulatory framework with the aim of investigating the effects that the new technologies can have on safety and security, on the environment, on the facilitation of trade, on shipping costs, and especially on onboard and ground personnel, because there will be also some issues related to labor law. In 2017, following a proposal submitted by some countries, the MSC, so the Maritime Safety Committee of the IMO, put on the agenda a study, which is still in progress, aimed at verifying whether, how, and within what limits the so-called IMO instruments are able to provide an adequate regulatory framework also for the activities of AMAS, so Maritime Autonomous Surface Ships, which has been defined by the IMO as a ship which, to a varying degree, can operate independently independently of human interaction. So we have to remember, also in consideration of the elaboration and development of the topic this lecture, that the MSC, so the Maritime Safety Committee, has clarified that the degrees of autonomy are different. And there are at least 4 different degrees that comes from the first one, where there are just automated processes and decision support on the vessel, to the last one, which is related to the fully autonomous ships, where the operating system of the ship is able to make decisions and determine actions by itself. So a first result of the studies of the MSC, the Maritime Safety Committee, not the MSC Convention, has the first result that has already been achieved is the one that was gained after the approval of the interim guidelines for mass trials in 2019. In one of the sessions of the MSC, I think it was session 100 or 101 of the MSC in 2019. But clearly there's a lot of work to be done, still to be done. So, in parallel to the work of the IMO, the Comité Maritime International, the CMI, is also giving its valuable contribution through an international working group, through an EWG, focused on the topic of maritime law for mass, which has already delivered a document called the CMI International Working Group Position Paper on mass, and collected the answers of the National Maritime Law Association, the MLAs, to the question prepared on unmanned ships. Then, in addition, the International Working Group performed a detailed analysis, article by article, of the IMO conventions, highlighting the issues that arise in relation to their application to mass, listing the needed clarification and suggesting the possible amendments, and is a sort of consolidated analysis of the IMO conventions. So what already emerges in a rather clear way from these studies is that if, on the one hand, the progressive introduction of mass in commercial transport could bring with undoubtedly benefits, both in terms of saving certain costs and in terms of drastic downsizing of accident at sea, considering that statistically 80% of this kind of accidents are caused by human factor. On the other hand, it will give rise to new problems. In fact, the negative impact in the social and employment fields for all those who will no longer be able to provide their services on board is undeniable. And then also the difficulty of identifying the legislation applicable from time to time and of making the related appropriate adjustments is evident to everyone. Then I have to point out that anyway, the human factor, even if reduced in case of mass, it will continue to play a non-secondary role in for what concerns the remotely controlled operations in programming the driving systems and even the liability, on which now I will focus on, will not disappear, but it will just shift from one subject to another one. So probably the most complex challenge for policymakers, but in general for all the stakeholders and for the interpreters, and so the lawyers and the judges and so on, is at this stage the identification of the subjects, of the entities toward whom liability for operation of unmanned ships shall be channeled, and consequently to identify the system of liability to be applied. So in a way, the activity that an interpreter should perform at this stage are substantially two. One is on a short-term time horizon, and the other one is in a medium-term horizon. So the first activity to be performed is to experiment the flexibility and the ability of adaptation of the actual regulatory framework to this new phenomenon of mass, in order to verify if it's sufficiently reliable and capable of giving answers. And in a way, the studies of IMO and CMI showed that substantially these systems can be considered valid, even if with some bottlenecks. And the second activity is trying to start to perform the necessary adaptation and updating intervention at the regulatory level. So the choice of the regulatory approach to be followed remains the most important one, as it is to some extent preparatory to those regarding the interpretation of the discipline in force, revealing its nature as a guiding criterion for the interpretation of the discipline itself. So this is all the more valid in a matter such as this one, in which there is a risk that not well-shaped regulation could become an obstacle both to technological progress and even to commercial use of mass. So, as often happens, the identification of the line to follow is far from easy and is affected by a phenomenal fact. So, the evolution of legislation and of the same technology and of the behavior of the operation of the relevant market are close interconnected. Are so interconnected that it is not possible to predict with certainty what the final framework will be, in the full awareness, however, that this process is in constant becoming. On closer inspection, I would say, new technologies always gives rise, also in the case of mass, to new problems. And if it is not possible to give a full solution to them by means of the rules already in force, the policymakers must implement an evolution of the regulation in force, introducing new norms or modifying the existing ones. also in light of the interest of the stakeholders involved, and also considering that the stakeholders have interest often conflicting with each other and variously declined, even in terms of intensity, by virtue of not always homogeneous ability to make one's voice heard. So once the new legislation come into force, the technology symbiotically reacts to it. So designers and manufacturers find themselves involved in an endless dance between having to be compliant with the new norms in design and creation of products on the one hand, and looking to satisfy the constantly changing demands of the market for products that push the limits of the existing discipline on the other hand, until the process reaches a critical point and the poetic cycle repeats itself. So the complexity of the operation is therefore the result of the inevitable interaction of multiple factors. Among these, there are also the choices of societal policy, not fully predictable in their final outcomes, as well as the evident temporal misalignment between the rather long times required by drafting of valid and effective rules, especially at uniform international level, and the much greater speed with which a new technology is born and developed. So for the then again, a further complicating element is given by the contextual presence of various forms of regulatory instruments in terms both of quality and terms of extension of territorial effectiveness. So to the sources attributable to the hard law model, which in turn can be distinguished into international uniform, macro-regional, bilateral, or domestic or national, are added the ones of soft law, guidelines, standards, not binding codes of conduct, and also sources of purely interprivatistic obligations in light of the freedom of contracts, which even if they are not qualifiable as norms in the proper sense, they have force of law between the parties. So the legislator does not always maintain full freedom of choice of the approach to be followed, as in some areas, especially in the maritime sector, practices have been established that have remained constant and unchanged for a very long time, for decades and decades. And so relational models have emerged between the operators by now emerged between the operators are consolidated and difficult to subvert. So if we, for example, think to the shipbuilding sector, where the obligation and the distribution of liabilities between the parties involved are determined and negotiated almost exclusively at the contractual level, on the basis of independent contractual relationship, in which the yard's suppliers do not have a direct relationship with the ship owner. So this circumstance, for example, clearly would make it more difficult to follow in case the path of reform of the liability system regarding the construction of mass. A liability system in which risks and liabilities can be simultaneously shared between all the parties involved, suppliers, the yards, the ship owners. So, all things considered, historically, the regulation of the world of sea transport is strongly anchored to the International Convention, even if in more recent times a copious normative production has been developed at EU and national level. So effectively, having rules for mass established on the basis of international instrument could perhaps be the best solution even today, which would allow to avoid overlapping or unaligned disciplines between different jurisdictions and the consequent deplorable practice of forum shopping, which also ends up altering competition on the relevant market. It is evident that only a homogeneous regulation, both from the design and construction side and for the operation of the mass, can allow true widespread use of the mass all over the world. Nonetheless, one must be aware of the finalization of the international regulation is not realistic on a short term. This is a medium or long-term goal. So, with a view to more immediate protection of the interest of industry operators, such as ship owners, yards, suppliers, among the suppliers there are also software and other producers and designers, and remote operators, the intervention of national legislators is desirable. The domestic legislator, especially in the sector of cabotage transport, can at least partially remedy the regulatory gap, pending a uniform international intervention, which in the abstract and in the light of other recent examples for similar cases, we can think to Polar Code, for example, could consist in a mass code. A key role in this first phase could also be played by classification societies, especially in the definition of technical standards and code of conduct. Honestly, we have now to reflect on how, in practice, an adequate regulatory process in the matter can take shape. So, given that until today the legal framework has been able to respond effectively to the needs of the subject that typically animate the maritime transport market, reflecting the elaborate setup progressively structured over the centuries, and managed also the relationships between them, and managed to preserve the delicate balance between these relationships. For the time being, in my point of view, it would be wise for the national legislators to intervene surgically. So, if possible, the domestic legislator should act under the coordination of a representative institution of macro regions, in case of EU, the EU institutions, in order to allow a certain uniformity and at the same time don't create obstacles to the future entry into force of an international uniform regulation, which is at this stage still in fear. So, in other words, any perhaps desirable far-reaching reforms should be implemented to an international uniform level, so to avoid the emergence of jurisdictional issues, while at domestic level, efforts should be made to bring, as far as possible, the mass into the existing regulatory framework, integrating with target and well-calibrated actions, so surgically, only those specific areas unique to autonomous ships that still appear to be without discipline. This is also in mind of the fact that, however, the role of some actors, such as ship owners, in the end remains the same as before. So, if from the structural point of view, these regulatory interventions must be based on the guiding criterion of a narrow and precise scope of application, conversely, as regards their content, it is appropriate that they are not too detailed and prescriptive, so as to allow those who will have to apply the law an essential margin of maneuver in an area the one of new technologies, which is intrinsically devoid of well-defined boundaries. So the best solution, therefore, could be to develop, let's say, a goal and risk-based discipline, which provides principles common to those of other models of transport, where autonomous vehicles find space, and which, having as a reference also the industry technical standards and code of conduct, will then be able to valorize the peculiarities and specific risks of both sea transport and the level of autonomy of individual types of mass. So to this end, it is certainly essential to also rely on the activity of multidisciplinary working groups composed of experts coming from multiple sectors, which are in various ways affected by the phenomenon of mass. Scholars, technicians from realities dedicated to the design and implementation of digital technologies, representative of seafarers, figures from the world of shipyards, ship owners, and others. So all the stakeholders involved. This would allow not only to have a broad view of the interests and needs at stake, which should already have been acquired through a stakeholder survey, but would allow also to achieve a deeper and more precise understanding of the operating modes of navigation system with different degrees of autonomy, the mechanism of transferring control capacities and decision-making responsibilities from human to machines, and the additional potential and risks of this kind of artificial intelligence. So in this way, probably the boundaries of the phenomenon would be better identified, so as to be able to find more easily an adequate balance between regulation and technology, drafting a discipline not too dependent on the characteristic of the latter in each specific case, but neutral as far as possible with respect to the new technologies, and able to avoid falling into error of over-regulation. Now we have to shift and focus our attention on the core of my research in a way. So truly the possible solution concerning the identification of the subject of the entity liable in case of accidents happened to mass. So in my point of view, there are the uncertainty, the current uncertainty concerning the system of liability to be applied to masses have at least two undesirable consequences. Firstly, the increase of the premiums charged for liability insurance. Secondly, the inability to predict their liability costs, which might deter manufacturers from investing in the development of autonomous vessel technology.
Welcome to the blockchain document transfer demonstration on the clock.
Sorry.
we can focus also on the blockchain demonstration. It's another topic I would like to deepen a little. So coming back to the research, it is essential, given these two problems, it is essential to verify which can be the nature of the liability regime for mass, if it should be subjected to a regime that is a little bit different from the one that is now applicable. So the possible solutions, in my point of view, are different and varied, and are substantially three. The first one is imposing a strict liability regime, The second one is strengthening the fault-based liability, transforming it in a sort of enterprise liability. The third one is to apply the product liability regime. Then there will be the fourth one, that is my recommendation, let's say. Let's focus on the first one, strict liability. So clearly, it shall be pointed out that in maritime law, there are already strict liability systems, such as the one provided by the CLC and bunker conventions. Then it can be stressed that the strict liability regime can be appropriate in cases where the vessel is autonomously operated for a number of reasons. For example, given that the size of the total software package is probably huge, and things can go wrong, and things that can go wrong can be numerous, a fault-based liability system could be detrimental to third-party claimants, as it would be probably impossible to succeed in the process of apportioning fault between different parties involved in the design of the technology. Then again, another reason could be the ethical issue. The ethical issue shall be taken into account. Algorithms used in mass will reflect ethical values of the humans who design them, especially when there is a situation where only poor alternatives are left, such as in the case in which the mass has to decide whether to hit another ship with passengers on board or a ship carrying oil in bulk, causing an environmental disaster. And this will create a difficulty for the courts in determining the degree of fault. So again, another problem is that in future, truly intelligent mass could be able to process inputs coming from the world around in a fully autonomous way, taking choices that could be not consistent with the ones of the original designers. In that case, it would be nearly impossible to allocate fault on the designers. But we have also to consider that some exceptions to a strict liability regime shall be provided. For example, in case of hackers that manages to penetrate the IT systems, taking control of it and causing damages to third parties, the ship owner not necessarily should be considered strictly liable, given that would be the case of an incident caused by an act done with the intent to cause a damage by a third party. So it would not be advisable to have to give all the liability to the ship owners, on the shoulders of the ship owners. Obviously, it's suggestible to have an insurance covering cyber risks as well. Then again, another exception to the system of strict liability, it would be the case of a vessel which is not fully autonomous, but under the control of an offshore control station. In that case, the liability should be fault-based. The same would be valid in case of a collision when the mass is not in operation. So, in case a strict liability regime will be the one chosen for mass, the most complex issue is the one of determining the subject whom the liability should be channeled to. Perhaps it would be advisable to resist the temptation to identify such subject in a manufacturer, even that not only there could be more entities that can be qualified as manufacturer, programmers, shipbuilders, etc., but it would still struggle to find insurance coverage. So, in fact, it's unlikely that P&I class, protection indemnity class, will provide such coverage, and the same could be true for a more classic insurance company, given that the current regulatory frameworks does not provide for a limitation of liability for manufacturers. So this reason would lead to identify the ship owner as the subject towards whom to channel the liability. So the ship owner could bring afterwards a recourse claim against the manufacturer for the liability he has incurred in case, only in case, the ship owner manages to demonstrate a fault of the manufacturer that is causative of his loss. So the manufacturer, however, does not have the right to limitation liability. Therefore, we should, in this case, reason on drafting a clause similar to the Himalaya one, trying to qualify at the same time the manufacturer as an auxiliary to the carrier. So what about the second possible solution? So not creating a system of strict liability, but a system which strengthens the fault-based liability, transforming it in a sort of enterprise liability. So it's not an enterprise liability is not clearly the same as a strict liability, but is not too far from it. So enterprise liability is a kind of a vicarious liability where are evaluated the effects of the action or omissions without inquiring too deeply into how the errors were committed. So it's more strict than the vicarious one, but is not fully strict liability. If this solution were to be opted for, it would be necessary to reflect on how to behave with the international convention currently in force. For example, the Collision Convention provides for a system of a fault-based liability. So in other words, it would be necessary to decide whether to denunciate those conventions in force, to modify them, or consider them regulating particular cases as lex specialis. Third possible solution is to apply the product liability regime. So we all know that the EU discipline of the product liability regime is has been set by the Directive 374 of 1985. So it's a system that is nearly 40 years that exists. And it provides for a system of strict liability for damages to persons and without limitation. The fact is that the problem of defective products damage would also exist for non-autonomous ships. Given the extremely broad definition of product offered by, I think it's Article 2 of the directive, so a product is considered all movable property, even if incorporated into another property, into another element. So, therefore, we should ask ourselves why, until now, there has never been any recourse to product liability in cases of damage caused by the ships due to malfunctions, for example, of the furnaces or the electrical system. So perhaps this system of liability should also be rethought in order to apply it to mass. And in addition, there would be two further problems. Firstly, it is not yet clear whether the software itself can be considered a product. Secondly, there is a risk that in cascade, product liability also falls on individual manufacturers who create individual software or hardware components. So given these three possibilities, also in order to conclude, because I spent more time than I expected, in my opinion, there could be a fourth possible solution, which is more complex but in a way more flexible and balanced. And the fourth solution is to combine the possible application of two systems of liability. That of product liability, when it is proven that the event is caused by a software defect. So the designer producer must have compulsory insurance coverage with a minimum limit similar to that provided for ship owners at EU level, for example, even if two problems remain. First of all, the cost for the designer and producer to obtain insurance coverage would be pretty high, a circumstance that would create barriers to entry into the market. But in practice, the software producer and designers would be very large companies, I think to Apple or Microsoft, so it would not be a so big issue. The second problem is that there is a risk that proof of the cause of the damage may occur once the typically maritime time barred period has expired. If the other system of liability to be applied in case the one of product liability wouldn't be applicable because it is not proven that the event of damage has been caused by software defect, the second system is the one of a strengthened fault-based liability. When the damage did not system, but to a maneuver carried out, for example, by a remote controller, if the mass is not fully autonomous, or in a residual way when the cause cannot be identified. So this is my the summary of the theory that I'm trying to write down in an article that I'm writing now. Thank you very much.